Thank you so much for joining us today at the JCF Professional Advisors Network webinar. I'm going to turn the stage over to Jenny Udanin.
Hi, this is Jenny Udanin. As Yafa introduced me, I'm the chairperson of the Professional Advisors Network of the Jewish Community Foundation. As you know, we are always trying to be on the front lines for our professional community in the greater Metro West, but we're particularly proud to be here today, and we thank you for joining us as a resource to our professional community during this difficult time. So today's seminar will cover remote estate planning execution, and the next seminar will cover insurance issues that are peculiar to these peculiar times that we live in. If you have any other topics that you would like to suggest, we'll be happy to entertain them, and we will try to arrange webinars on those topics. I want to thank our presenters, Gary Botwinick and Anita Siegel, both of whom are very well-known professionals and community leaders here. And I also want to thank the staff of the Jewish Community Foundation for organizing this webinar. So with that, I turn the floor, so to speak, to Anita and Gary.
Good afternoon. As you see, we're going come from away, how to succeed in planning your estate without ever entering your lawyer's office. We're going to talk about a bunch of different topics. We're going to start with how you get started planning your estate. And we know that an in-person meeting is best. And historically, we've always done that. We've met with clients in person at least once, and sometimes multiple times. Body language is important, how spouses interact, sure that no one else is listening into the meeting or pushing anybody in any direction. Think, if you're old enough, the Kennedy-Nixon debate. Who won depended on whether they listened on the radio or watched on TV. So we know that being in person is important. But what do we do when we can't be together? Well, the first thing we can do is have a telephone conference. Conference call lines make this doable, but we lose a lot. Is anyone listening in? Is anyone impacting what is being said or who says it? Some older people don't hear as well on the phone as when they see the speaker in person. So what else can we do now? And thank you for computers. In this day and age, we have a lot of choices. We can go with FaceTime, Zoom, as we're doing today, Microsoft Teams, or a similar meeting portal. That gives us the opportunity to see the body language and demeanor, because those are often very important factors. How the couple or sometimes the parent and child interact is very important. Any influencing going on that you might not hear in the voice, you might see in the physical demeanor on the Zoom meeting. This may prove challenging with our senior clients as they don't work real well with technology often. For the elders, we can get not their children, but their grandchildren to help with setting up their meeting online. But we also have to be very mindful of security issues. If anyone is listening in, if anybody else is out there who shouldn't be, a family member, a healthcare aide, a neighbor, a personal secretary, these are all people who sometimes get in the way of the independence of the individual in making their decisions. We don't have that in a personal meeting when we are sitting around the table and just those of us at the table are hearing what's going on. Could this be recorded? Should it be recorded? Is that a good idea or not? We have to keep in mind that our clients are not trained actors. They can get very nervous when they know they're being filmed with that camera rolling, and they might seem less capable than they are. We have seen this both on the planning side and as well as at the time of signings. And if somebody is being signed because we think there might be a will contest coming up ahead, we may find that they sound less secure with the camera rolling. But again, having the FaceTime or Zoom type meeting is really helpful to know that nobody else is there. We also want to remember that before the conference ever happens, whether it's in person, by phone, by Zoom, by FaceTime, whatever, we still need the information from our clients. We need an estate planning questionnaire, at least that's what a lot of us call it, which gives us both the family information as well as the financial information that we are planning for. It can give us a lot of insight into what needs to be done, and we want to see it before the meeting, before we make any recommendations for the estate plan, and certainly before we prepare any of the estate planning documents for the client. So we want to consider moving to an online format. Texts and emails are helpful, but we still need, hopefully, that face-to-face, even if the face-to-face is on Zoom or FaceTime. What documents do we need to plan for? Let's think about all the different documents that we need in terms of an estate plan. We start out easy. We start out with the last will and testament. But I'm a strong advocate for the pour-over will and revocable living trust for most clients. There are so many benefits to having a revocable living trust. And of course, that came out of states like Florida, where there were all kinds of issues. But even in New Jersey, it's really, I believe, very beneficial. It gives us privacy, both during the life of our client as well as at death. We can use the lifetime trust during life. We can use it to help manage assets for somebody who no longer wants to or is no longer able to manage their own assets. It's especially important in the event of a disability or advanced age. It also gives us simpler administration after death, because if I have a trust established under a will and I need to make a change in the trustee due to a death or illness or resignation, I have a court proceeding, or at least a surrogate proceeding to go through, whereas a living trust is a contract and the successor takes over because they're the successor. Much easier during life as well as after death. The ease of the administration of the estate. There's no 10-day wait to have the will admitted to probate. The trustees are the trustees as of starting with the date of death, if not before. There's also no need for tax waivers, so there's no delay in the access to the funds when funds are transferred to the revocable living trust during the client's lifetime. So I'm a strong believer in the revocable living trust. I think it works really well. And then what some people say is, well, but it's hard to get my clients to fund the trust. Well, you help them, first of all, but second of all, the power of attorney, our next document that is essential, the person holding the power of attorney can exercise that power in favor of moving the client's assets into the client's living trust. If the reason we want it now is because of the incapacity or just the lesser capacity of the client. So the power of attorney, of course, another essential document. Even if I have a will, even if I have the revocable living trust, I need that power of attorney, because there are always assets sitting outside of the trust that may need management, a car, other tangible personal property, a checking account, things of that nature. We also need the healthcare directive with living will. The healthcare directive is the appointment of a person to make medical decisions for our client if they are not able to do so themselves. Very important. We think of end of life decisions, but it's also during life. Take the example of the client who's in a car accident, is in a temporary coma, and needs somebody to give the doctor approval to fix the broken leg. So the healthcare directive is a very important document. The living will component is, what do we want to happen if we are in the end stages of life? Are we willing to have nutrition and hydration withheld or not? Do we just want measures to keep us comfortable, but no extraordinary measures to keep us alive? Or are we saying, I'm not done yet, so keep working on me? It's your opportunity, it's our client's opportunity to express their desires for what they want to happen if they are in that end of life situation. And by the way, the power of attorney and the healthcare directive are really good graduation from high school presents for our children and grandchildren, because when they go off to college, they may need help in either of those. And don't forget, once they turn 18, the parents don't get to go into the doctor's office with them anymore without this. The HIPAA is not a decision-making document. It is the document that appoints the people who can have access to the protected medical information. It's the person who can go to a doctor's appointment with the client, who can sit in the waiting room while the client's having a procedure and get the results of the procedure from the doctor. And so the people on the HIPAA are certainly the people in the power of attorney and healthcare directive, but could be more if we think there are other people who might be involved with the client's care at any time in the future. Part of the estate planning is taking into account those assets that don't pass under the will or trust, possibly, because they have a beneficiary designation. So we need to see the beneficiary designations of all the life insurance, all the IRAs, the retirement benefits, anything that has a beneficiary on it. We want to see the current forms, and probably we'll be changing them once we put a plan in place. So we will be assembling change of beneficiary forms for that life insurance, IRA, other retirement plans. And this is a time when also to tell people to get their children and grandchildren's name off as a POD person if we want the will and trust to govern where the assets go. Planning for retirement benefits has taken a real turn lately because of the Secure Act. And so we really need to focus on that. Even clients whose documents are only a year or two old may be out of date when taking into account the Secure Act, since many of our clients have as their two largest assets their home and their retirement funds. So we need to really focus on the Secure Act and those change of beneficiary forms and changes in the documents that are needed for those. Think also about other trusts that our clients might be interested in. If we have a significant amount of life insurance, we might be looking at ILETs, or we might be modifying ILETs. We might be saving for children or grandchildren and use 2503C trusts for minors. And some of our clients who are charitably minded might consider using a charitable remainder trust as part of their planning. So these are all documents you need to consider. Now I turn it to Gary.
Thanks, Anita. Make sure I'm on. I am on. These are trying times. They are challenging times for attorneys, financial advisors, accountants, everybody trying to work with their clients. They've been doing things the same way forever, and now all of a sudden we have this bump in the road, and we've got to find new ways of doing things. I will tell you that we are as busy as we've ever been in having meetings with clients. There's nothing like a crisis to prod clients into taking care of things that they had neglected. I can't tell you how many times we've heard from clients we hadn't heard from in a long time, all of a sudden wanting to move forward with their estate planning. So that's wonderful. And I know, speaking for Anita, we are meeting with clients online, and I'm finding it very productive. These technological advances we've had over the last 10 years have made this sort of planning much easier than had this crisis happened 10 years ago. So we are using the Zoom software. We're using Teams and other products, even just conference calls, to interact with our clients. It's obviously not as ideal as having the clients right there in front of you, but we know that that's not safe. And you'd be surprised at how much you can accomplish on a Zoom conference call. Maybe you wouldn't be, because I'm sure all of you are using these technologies yourselves. So where the rubber meets the road, though, and where we sometimes run into problems, or where we first identified there were going to be issues, were with respect to documents that required notaries. So one of these documents that typically we would use a notary with is a will, last will and testament. There are certain standards that you are looking to accomplish in order to have a will that you can probate and be effective. So one of the, I guess the gold standard for a will is a self-proving will. This is a will that would have a special attestation, notarization at the end of it, where the notary would acknowledge that the testator testified as to his or her capacity, the witnesses were all available, and they all understood that the testator had the capacity, and the notary would sign this, and that makes the probate much easier when the testator passes. To be self-proving, though, you need a notary, and up until recently, that was proving to be a problem. We'll talk about some new legislation that was signed into law a week ago, and how that makes things much easier when we get to that topic. The will can be self-proving. In order for a will to be effective, though, you do need two witnesses. While that does present challenges, we are finding new ways to accomplish these things as we go through these coronavirus times. You can also make a will self-proving after the fact under NJSA 3B3-5. So that means if a client signs a will outside the presence of a notary or outside the presence of witnesses, these are things that we can remedy after the fact. The problem is what happens if the testator dies between the time of the execution and the time we get to fix these things. I've cited there 3B3-2A3, which talks about the fact that the witnesses in a perfect world would be with the testator when he or she signs the document, but they don't necessarily need to be, as long as you have witnesses within a reasonable time after each witnessed either the signing of the will or the testator's acknowledgement of the signature of or acknowledgement of the will. This can be done, we believe this can be done remotely. I wouldn't say that that's the best practice. Best practice would be to have witnesses there, which we'll talk about. Powers of attorney do need notaries. So just sending off a power of attorney to a client and having them sign it is not going to be effective. Likewise with deeds, and oftentimes deeds are an important part of an estate plan. So keep that in mind. If you are having a client execute a deed, for example, they have a revocable living trust, we want to move that property into the revocable living trust, we are going to need a notary for that. Moving on to the next slide, what documents don't require notaries? And some of these are really important, especially in these times. Anita touched on healthcare directives and HIPAA releases, HIPAA authorizations. These don't necessarily require a notary so long as you have two witnesses. So if you cannot have a notary available to witness, to observe the execution of these documents, that's going to be problematic unless you have two witnesses who can do that. Trusts, as Anita mentioned, revocable living trusts are good planning, excellent planning techniques, planning device. While we usually like to have notaries, they are not required. So a trust can certainly be signed outside the presence of a notary. A holographic will is also something that does not need a notary, nor does a writing intended as a will. The problem with these documents, and a holographic will is a handwritten will by the testator. The problem with having a holographic will or a writing intended as a will is that even though you don't need a notary, it does present some problems when you go to probate when you go to probate the holographic will or the writing intended as a will. There's a higher standard to get these documents admitted to probate. So with that, I'm going to hand it back to Anita to talk about how to accomplish document execution outside the usual office scenario.
Thank you. It's interesting because it really depends on what we're going to be signing. But in the typical case, we're signing a full set of documents, which is wills, trusts, powers of attorney, healthcare directives, the HIPAA and change of beneficiary forms, all of those things. And so it's a time-consuming meeting. And before the current problems, it was time-consuming. Now it can be even worse when we can't all get together in the conference room. So what are some of our choices? And I'll go over some of them and then give it back to Gary. One is the office signing. We can try to be extra careful by using separate rooms for the testator versus the witnesses versus the notary, everybody in a mask, gloves, single-use pens, separate pages to sign on so we don't have everybody signing on the same piece of paper, cleaning our tables before and after the signing. Social distancing of at least 6 feet or more makes this very difficult in most offices, especially small ones. New information says it's really 9 or 10 feet that we need to be apart, but you know, anything that you can be apart has to be helpful. So the office signing is problematic. Do we want to get together in a room with these other people? Hopefully they're healthy, but we really don't know. Another possibility is going behind a closed door, glass door, or a glass window. Because when it comes to notarizing and witnessing, if you can see and hear the other person, even though there's glass between you, it's still a good signing. So I kiddingly say you could stand in the bushes outside the picture window of your client's home or on the other side of the glass storm door and pass the papers underneath the door. That's a possibility. If you can get glass between you, then we're not going to have the bugs flying back and forth. Another possibility is what we kiddingly call the drive-by signing or the back of the car signing, where everybody brings their own pen. We put the papers on the trunk of the car. Hopefully you don't have an SUV, or on the hood. And people come over to the car and sign and step back away from the car when it's not their time to sign. And when we're outdoors, there's a little bit more comfort in knowing that you're not just in a closed room with a closed air conditioning or heating system. So that's a possibility. So we can keep our social distance and pass documents in and out of the car if the client wants to stay seated in the car or do it on the back of the car. There's also the picnic table or the backyard patio furniture table. Again, we still need to have our social distancing. We need to be separated even though we're outdoors when it's harder to get witnesses and or a notary out to a park. But again, we can have people who are standing more than the 6, 8, 10 feet away and then step over to sign, but they see and hear the person signing. So those are some ways. Now, Gary.
So we've already done many of these. I happen to like the drive-by signing. In fact, somebody who's on this call, we did a drive-by signing recently, and we did sort of a combination of number 2 and number 3, where because of the way our office is situated, the testator pulled right up to our building. We opened up the windows. The testator rolled down their window in the car. We opened the window in a conference room, and we were able to do a combination of things to get these documents signed. So they say necessity is the mother of invention, so we're all finding new ways to do things. An easy way is the witness watches from a distance while the testator signs the document. I did one like that yesterday in our office. We have a rather large conference room. I had the testator sit at one end of the large conference room, and I stood in the doorway with the witnesses and myself as the notary, and we were able to guide the client through the documents and have him sign the documents appropriately. Now, we encourage you to wait 72 hours in case there's germs on the documents. As I mentioned before, the witnesses just need to sign within a reasonable time after observing the signing. So that works. In our case, we used gloves. I'm not sure that that necessarily guarantees that we're protected, but we felt comfortable doing it that way. But it is important, number 6, that the notary must be able to see and hear the testator sign, testator or the signer without technology. In other words, that the notary, in my case, I said we were in the doorway and we were able to see and observe the testator. Likewise with the drive-by with the windows open. That also was really helpful. Now, that brings us to number 7. So there was a statute, there was a legislation that was passed very early on in this COVID shutdown, which was not signed by the governor and which was supposed to be effective for whatever reason 90 days after execution, after signing by the governor. That really we determined, the bar figured out that really wasn't going to work very well. So there was over the next couple of weeks some changes to the legislation, and now we have a new remote notarization statute. You'll find it at New Jersey A3903. There's a hyperlink, I think that's what they call it, on the PowerPoint, and I believe we've included it at the end. This says that the notary does not need to physically be in the presence of the signer. In other words, that you can have a virtual notarization. However, there are certain requirements. One of the requirements is that you need an audio-visual recording of the ceremony. I'm not sure, I believe all of you see in the upper left-hand corner of this program today, you'll see a red light flashing and a recording. This is Zoom, and we are recording this. So this would be something that this Zoom is a great piece of software. I know there's been some issues with it, but it does allow you to record the ceremony. In doing it this way, the notary doesn't need to be in the physical presence of the signer. But you do need evidence of the identity of the signer, or you need to have personal knowledge of the identity. So one of the things you might want to do is, if you're recording it, you might want to have the testator show you their driver's license or passport or some form of identification. That's certainly helpful. Also, you need to reasonably confirm that the document that the notary is observing is the same document that the signer is signing. So what you might want to do is send the documents to the client in a FedEx envelope or some other means of transporting it, and then have the client open up the documents in your presence and hold them up so you can see that it is in fact the same document. That way the notary can confirm that the document is the same one that the signer is signing, and that the notary is looking at his or her office. Now, the most important thing is to create an audio-visual recording of the performance of the notarial act. So the recording of the document of the signing of the document is very important. What I believe is the best thing to do at that point is, once you have the recording, is to save it on your server, as well as save it on a thumb drive. What we're going to do is we're going to save those thumb drives with the original will, throw it in the original will, and keep it in the will vault with the will. Now, the best, of course, is if the client can gather 2 witnesses and a notary, and then you can send all of the documents to the client with very explicit instructions, with the sign here's, the stickies on there, and tell them to, and guide them through. You could even guide them through visually, and you wouldn't need to record it because the notary would be there with the testator. Now, keep in mind, although it's not ideal, an interested party, in other words, a child who's a beneficiary under the will, can act as a witness. So if you have a family that is shut in together, and you have a husband and a wife and 2 adult children, those 2 adult children can act as witnesses, and then hopefully you can have a notary in there as well. Unlikely in these times, but it's possible. So those are how those are the mechanisms we're using to accomplish document execution outside of the usual office signing. I think there's probably other ways that we haven't really thought of. As I said before, necessity is the mother of invention. So if anybody has any good ideas, feel free to shoot us a chat or a question, and we'll get to it at the end. And I'm going to hand it back to Anita.
All right, what if you can't gather 2 witnesses and a notary? Is there something else that we can do? Well, one of the things that we're thinking about doing for certain clients who are in a big rush is to use the holographic will. That's a very short pour-over will. The attorney will type out what they want in the document and send it to the client, so the client can copy it over in his or her own handwriting on their own paper. It should say, "This is my will. I appoint X to be my executor, executrix of my estate," and don't forget to include a successor just in case. "I leave all of my assets to my revocable living trust dated today," sign and date it, and that is a good holographic will if it's all in the testator's handwriting. The problem, of course, as Gary mentioned before, is the holographic will requires a formal probate. Doesn't mean it can't be done, but it is a little bit more cumbersome in time and money. So the living trust. Well, as we noted, the living trust doesn't require a notary. It doesn't even require a witness. As a general rule, we use a witness and a notary to sign our living trust, but they're not required. The grantor can be his or her own trustee, and again, we have successors appointed. All the dispositive provisions for the assets are drafted by the attorney, and everything is typed in a document which will be signed by the grantor. We can email the document to our client, they can print it out, and they sign as both grantor and trustee. Witness and notary are not required, but it is good practice, especially again, if there's going to be real estate in there. But also, as Gary just mentioned, the witness can be a beneficiary or a related party. We prefer not, to avoid the appearance of any undue influence or otherwise, but if we have a typical plan where I'm treating all my children equally and there's no suspicion in what's going on, I think that is fine. So the combination of the holographic will and a living trust allows us to get this done really with just a signature of the grantor, if we have to, if we're in a real hurry. In the writing intended as a will, which is relatively new here in New Jersey, there are no formalities required. It can be on the back of a napkin. It can be a computer draft. It might not even be signed, but we have to consider an acknowledgement statement that the testator is signing it, intending it to be his or her will. It does require a court proceeding and clear and convincing evidence to have this document admitted to probate as the will. But again, in emergency, sometimes that's what we do. If we're going to use any of these methods, we do want to have that CYA letter and acknowledgement by the client after the pandemic ends. What we'd really like is after the pandemic is over, the client comes into the office and formally signs all the documents after the restrictions are lightened and health concerns are lessened. We seriously question the wisdom if a testamentary plan is unusual, so such as unequal treatment of children, etc. So to the extent that we can get documents formalized after this emergency passes, it will be better. And I'm going to give it back now to Gary.
So thank you, Anita. So now we have to shift gears, and now we're talking about estate administration. You have a client who has passed away, and in the pre-COVID world, we would typically have the executor bring the will to the surrogate. Maybe we fill out documents and get them down to the surrogate's office in advance of the executor showing up. But that's all changed because they're all closed. They're not doing in-person probate anymore. So it's very difficult to move these wills through the process of probate. So what our suggestion is, because they seem to be changing on a regular basis and every county does things differently, is that you call ahead. Find out what each county's procedure is. I know Bergen County's procedure is online. If you go to the Bergen County Surrogates website, you'll see an online procedure. Morris County has forms online where you could complete the documents online and send them in online, and then you're contacted by a probate clerk who will guide you through what needs to be done. Essex County is all mail-in, and that includes mailing in the original will. If you are going to do that, my suggestion is that you make a complete copy of the will without taking the document apart. We always avoid taking the document apart. So if you can scan the document, copy the document, somehow keep a copy so that if something goes wrong in the mail or the probate office, the surrogate doesn't receive it, then you could at least certify that you did send it in and you maintained a copy of it. Some of them, as I said, have documents online. You go through it. I didn't survey all 21 counties, but on a county by county basis, I suggest you or the attorney or the paralegal find out what the procedure is. In some cases, the pleadings need to be notarized, and in that case, you can take advantage of the remote notarization. That will come in very handy, where your executor is in their residence and the notary is in their office. You can certainly do that. Again, remember, keep video, prove the identity of the person for whom you are notarizing the signature. You will also have to send in a death certificate with the will and oftentimes a check. Sometimes they'll tell you what the fee is going to be and you can send that separately. If the will is not self-proving, so we talked about holographic wills, we talked about a writing intended as a will, well, then you're going to have to file a pleading. You're going to probate that document in solemn form, and it's going to take a little while. I just had last week an order to show cause hearing over Zoom in Essex County with Judge Alper. They do work well. So if you do have to probate a will in solemn form, it can be done. It will slow down the process, but it can be done. So I believe that is the entirety of our presentation. Try to get through it quickly, but I know we did cover a lot of material. We did want to save some room for questions at the end, and I believe the way the Q&A works is there's at the bottom of your screen, there's a Q&A, and I think you can type it in there. Yafa will tell me if I'm incorrect or there's some other procedure for doing it. But Anita and I are happy to accept any questions that you may have. This is all very new, and a lot of it we're learning on the fly. And you can't foresee every circumstance that could possibly come up. So if you have an interesting question or a strange fact pattern and you'd like us to chime in, feel free. Oh, I'm also being told that I'm supposed to put up the poll.
No, sorry, that's us. We're gonna put up a quick poll. So we're gonna take Q&A and put up a quick poll just to see, get some feedback for our next webinar. We're gonna be doing webinars every Wednesday for now. We have another one next week on the insurance business and what's going on because of COVID-19, and it should be in the original email we sent you. But we're gonna wait a few minutes to see if any Q&As come in. If you can't work the Q&A, there's also a chat feature, so we can share questions through there. Oh, I see a question.
Anita, you want to take this one or should I take it?
I don't see it.
So I got it. It says for
Okay.
remote notarizations, are you modifying notary blocks to reflect that they are being done remotely pursuant to the new statute? Yes, I believe that is the appropriate procedure, is to acknowledge that you're doing it pursuant to the new procedure. And then again, keeping the recording and keeping that with the original document. Now, some documents, you won't be able to do that. For example, if you're notarizing a document that has, it's a form document, you probably are not going to be able to modify that. But I believe that you can just simply sign it as the notary. I believe that's consistent with the statute.
I believe that's true too, but I would put a CYA memo in the file that we did this. Here's the flash drive, and to prove that we did it in accordance with the statute.
Yeah, one more thing I forgot to mention. While this A3903 remote notarization statute is great, my hope is that we're not able to use it for very long, because this will only be valid while we're in this state of emergency. So hopefully we'll be using this for a very brief time. So if your plan is in 2022 to be using this, I hope you're not able to. I can read this question. It says, if a client is a New York State resident, but is currently in New Jersey and does not have access to witnesses or a notary, any suggestions on what to do? Holographic wills are not accepted in New York State. New York State allows for remote witnesses and remote notaries provided individual is located in New York State during audio video conference. Anita, you want to take the first crack at this?
Well, a document, most of our states say that a document that's properly executed in the state where it's executed is okay when you go back home. But this is an unusual circumstance for us to use our New Jersey remote notarization to sign something for a resident of New York. I'm not sure I'd feel real comfortable with that. And by the way, I hope remote notarization stays with us even after the pandemic, because I think it'll be really helpful to a lot of our seniors.
One other issue I have with this is it may be difficult to prove that the person is actually in New Jersey. Short of looking out their window and seeing Lucy the elephant and showing you that on a screen, I'm not sure how you're going to be able to verify that the person is literally in the state of New Jersey. So I think that presents some problems, and I would be very careful about executing a document in that way.
I agree.
Okay, thank you to Anita and Gary for this wonderful presentation. We will be sharing it online after after this. If you have any topics, again, that you're interested in learning more about, please shoot the JCF a quick email, and we will look into presenting it to you during this time. We hope that you stay safe and that you stay healthy. And thank you again for joining us.
Thanks, everyone.
Thank you.